Hello again, everyone, and welcome to Quigley on Divorce, the behind-the-scenes look. Today, I'm joined with one of what I consider our dream team, based upon a recent trial of my partners, Jared Pinkus, Jordan Rosenberg, and Marcus Dominguez. Our podcast today emanates out of a judge's decision and judgment that we just got in the door, which we're all very excited about, very proud about. But it kind of raised some really interesting issues. And just by way of background, it was involving a case that the divorce was finalized 2 or 3 years ago. And the parties had agreed to a 50-50 distribution of the parenting time and basically a division of the decision-making authority. Well, in the years subsequent to the divorce, the parties were back in court constantly, fighting over a multitude of issues. There were separate trials and hearings. And it got to the point where our client, the father of the 2 children, basically said enough is enough. Children need to be with me on a regular basis, and I need to have the decision-making authority. Well, as often is the case in these type of parenting disputes, the first thing the court did is they appointed a GAL, which is a guardian ad litem, and that's an individual appointed by the court. They're lawyers. They go through a training process. And the court appoints them sort of as the eyes and ears of the court to investigate the facts and circumstances. So we had a GAL. And then there was a request for what's called a 604 evaluator. We'll tell you some of the particulars on what those really mean, but it's basically a psychologist who came in and did an evaluation. And in this particular case, both the guardian ad litem and the 604 evaluator did evaluations, did investigations, and their conclusions and recommendations were that our client's position not be adopted by the court. And what's really, I think, significant to us in a case like this is the vast majority of cases we see where there is a GAL and a court 604 aligned on the same page. Most lawyers tell their clients, you're done. You can't win. Settle the case, fold up the tent, go home. We gave it the gold college try. That's not what we do at Beermann. That's certainly not what we do on the Quigley team here with these great lawyers that I practice with every day. We fight, and we fight and win. And this was something where the deck was stacked against us, against all odds. We got the judge who actually granted primary placement of the children with our client, and he has sole decision making on all of the major decisions affecting the children's medical care, their education, their religious upbringing, and even the selection of activities. So it was a resounding victory. But what was significant in that, again, is that most people, when they get those kind of recommendations, they blindly accept them. A lot of times judges will look at that, and unless you have good lawyers that can point out why following those recommendations doesn't make sense, like we did in this case, a lot of times the judges just adopt that. So I think getting into that as a backdrop of what we want to talk to you about, if you're in a situation where you're about to go into a divorce, you think there's going to be parenting issues with respect to who makes the decisions, where do the kids live. If you're in a case right now, and I will diverge one more time, Jordan and I tried a case where someone came to us 2 weeks before trial and said, look, my lawyer wrote me a 3 or 4 page letter, just said, settle. The GAL recommended against us. There's nothing we can do. You need to settle and try to, work out as best a schedule as you can. And this involved a mother trying to take the children after divorce to live in a different state. And we said, that's not how we would approach it. It's a lot of money. It's a big trial, but we will do it. And we got in there. We actually got the guardian ad litem's report knocked out, her testimony knocked out, and we won the case and prevented the mother from removing the children to a different state. So, Jared, when we get into these issues where the court appoints a guardian ad litem or a 604, there's really a process that we get into with our clients before it ever gets to them finalizing a report. Can you kind of speak to that in terms of what that process looks like and kind of what we do?
Yeah, sure. So you've got kind of 2 or 3 different players when we talk about guardian ad litems, which are another lawyer essentially who is considered the eyes and ears of the court. And their job is to do basically a surface level investigation of what they believe is in the best interest of the minor children, look at the different allegations that are raised, potentially talk to the children depending upon their ages and the nature of the allegations, and then write a report or report back orally the findings of their investigation, as well as what their ultimate recommendations are and opinions are. And again, it's just another lawyer. What we do when a GAL is initially appointed, it's incredibly important, number one, that we get our facts, our concerns, and our defenses directly to the GAL, so that when they do their investigation, they know what to ask, who to talk to, what they're investigating. We also prepare our client for their conversations with the GAL. Again, making sure that they're prepared with the necessary information that we think is going to be important at an ultimate trial, because that's what the GAL is going to base their ultimate recommendations to the court on. And while we know, the GAL may get it wrong, we may not agree with their recommendations, it's extremely important that the GAL have all of the facts that they need, that we want to get to the judge, so that we can then, on cross-examination or as we're making our arguments, we can point out all of the things that the GAL had in front of them, and just where they didn't properly connect the dots. Because at the end of the day, that's really what it is. The GAL in their investigation is taking what they learned through their investigation, dot to dot to dot, and then connecting that in one fashion or the other with their recommendations. The other two potential players in a custody case are the 604B or 60410B evaluator and a 60410C. Those are either psychiatrists or psychologists. The 60410B is an independent expert appointed by the court and charged with investigating what certain issues are present. They are going to prepare a written report, and their written report will entail should entail a lengthy recitation of everything they did during their investigation, who they spoke to, what they observed, and then again, tie that into their recommendations. Again, it's even more important in this phase that we provide the 604, that our clients provide the 60410B with all of the information that we want to make sure gets across to the judge, because that 60410B is going to, again, need to connect those dots to reach their ultimate recommendation. 60410C, it's almost the same thing, except it's an independent expert. Again, lawyers usually stay out of the process, but they are hired by the lawyers who disagree potentially with the 60410B to do your own private investigation. So what happens is, and we see it often, where the lawyers or the judges, they get this 35-page report from a 60410B, and what do they do? They turn to the last page. What were the recommendations? That's what we're going to adopt. You get custody, you get decision making, you get this amount of parenting time, and we're done. And if you disagree with what those last 2 pages are, the last page says, right? Well, the way you are able to rebut that, the way you're able to convince a judge, is by looking at the body of the report. So that's why the preparation is so important, because if you don't do the legwork early on, it's difficult to rebut.
So there's a lot to unpack there. And I think two really critical takeaways is, first, what Jared was saying, whether it's a GAL investigation or a 604 investigation, is preparation and the delivery of the message, because we often have clients who want to tell their entire story. They want to just, think they're going to basically be able to get in there and just talk for 2 weeks straight. We have to get the main points, and that circles back to the original strategy that we, the lawyers, create in terms of what message is being delivered. The other thing that Jared said, which I think is spot on, it is all of the dots that the evaluators are trying to set forth. Dots meaning, here's a fact, here's another fact, here's a finding, here's something else I've uncovered, here's what I believe. And ultimately, what's interesting is, and Jared, you started talking about this, is that leads to recommendations being made. And what we found in our case, the one we just tried and won, what we all believed as a team was that neither the GAL nor the 604 properly connected the dots, that the dots were there and it all made perfect sense as to what the judge should do, but they didn't reach that conclusion and recommendation. So Jordan, when you, to Jared's point, you see these reports, long 30-page reports, and they've got recommendations, and a lot of lawyers look to the recommendations and say to their clients, geez, the recommendation is against us. There's nothing we can do. What do you say to that, and what do you think the importance is in looking at the dots Jared is referring to and how they really connect versus what's simply in a recommendation?
And I mean, that's critical. And Jared, he helped us process a lot of information in what he just said there. But the dots are arguably the most important part of the entire report. And so just like Jared said, is most people just say, okay, well, we got the report back, we kind of punted, we got the recommendations. All right, I'm flipping to the last page of a 50-page report, understanding what the recommendations are, sort of ignoring all the meat that goes into it and the reasoning that backs up those recommendations. So what we found in this case is that actually the 604 and the GAL did a pretty thorough job in terms of their investigation and making factual findings, and that meat was very important and very illuminative of what the actual issues were in the case. And what they did from our perspective is they sort of muffed the transition from the facts and circumstances of the case as the investigation to the recommendations. And the way that we prevailed, what I believe, is that we really digested the report. And we sort of said, well, how can somebody say 1 + 1 = 2, but then with like a little, like a asterisk say, oh, but it actually equals 5. It, like, the logic in what they said did not make sense to what the recommendations were. And so we had a lot of conversations internally and saying, well, it's really the judge's job to make these recommendations, or to take the recommendations at whatever weight they want to give and really look at the facts and circumstances of what they were appointed for. The judge appoints these individuals to make these factual conclusions and to do investigation because, as everybody knows, the judge isn't going to your house and saying, hey, what do you think? What do you think? Meeting with your kids. Like Jared said, they're the eyes and the ears of the court who do factual investigation. So it's the judge's job to take the facts and circumstances from their experts in GAL and extrapolate those and applying the factors and determining what the best interests of the children are.
Yeah. And I think that really is what we did. We took all of those dots that required some analysis. You can't just read pages 29 and 30 of the report. We read 1 through 28 and we found a lot of really good dots. And then part of our job as lawyers is to persuade the judge how we believe those dots should be connected. And I think another point for all of us, and then Marcus, I'm going to want you to speak to kind of how we help put things together in a tangible way through exhibits and so on and so forth. But in a case like this judge had heard so much of this case for years that it was part of our strategy and our belief and the strength of our case that we had this belief that the judge had seen really who these people are through the years of litigation, which petitions they chose to bring, which arguments they chose to make. And we felt like we had a judge that understood enough that if we connected these dots and gave him the ability to draw that final conclusion, that the judge would do that. And in fact, that's what happened. So Marcus, as one of the guys on the team who was putting this all together, and Jared says, just even at the stage before we get the trial, preparing people for these evaluations, tell the viewers and the listeners kind of just some of this stuff, from charts to timelines to all kinds of stuff that mechanically we really spend a lot of time before the investigation even begins to try to put them in the best position so that these evaluators see things through the lens of our client's eyes, or at least from our perspective.
So when you get to the point of trial or doing an evaluation, it really comes down to the details. and finding a way to put all those little details that make up your family into something that's preventable and effective and efficient for either an evaluator or the judge. So in this particular case, we had one parent who was traveling a lot when they didn't have the kids. And so my job was to sort through literally thousands of documents from American Airlines, Spirit Airlines, and find a way to efficiently present it to the judge. We ended up having thousands of documents compiled into 4 or 5 pages that really illustrated how much the travel could impact the children. And that point was specifically cited in the judgment. Whether, the same thing happens when we go to trial on financial issues, where someone needs to sift through all these details, thousands and thousands of financial documents, or, someone's business, or, issues like that, as attorneys, every single sentence, every single word needs to be read and needs to be able to be compartmentalized and put before an evaluator or a judge. And, having a team approach, not only does that work get done, but it gets done at a lower hourly rate, saves you money for, when you're ready to come to trial or for evaluation, you're ready to go.
Yeah. And I would just a couple things off of that.
Jim, sorry, real quick. You mind?
Go ahead.
Sorry, I butted you out. I'm sorry. No, but it's a common theme that we always reiterate in all these podcasts is just organization, and how we have an intense ability to be organized and sort of just understand what trial prep looks like from a very early on stage. And so even if the case is just beginning, we're already thinking about what documents we're using as exhibits, how we organize that, who's doing what, and how we're allocating that work to try to organize it. So that's been tremendously helpful also.
Yeah. And so just, again, tying a lot of these different themes together, what Jordan just said is something we've repeated in many episodes, which is from day one, you have to have a strategy. You have to have lawyers that act strategically. One of the values of the 4 of us as a team is that we see sometimes the same set of facts differently. And we spend time challenging each other. We did that a lot in this case where, I tend to be like, we're winning, hard charge, let's go, we got it. But then there's other points of views. Hey, what about this? What about that? So I think having a strategy from day one is essential. And no matter what your divorce issue, no matter what the litigation is, you have to have a strategy going into it. To the point Marcus is raising about the work that has to go in, that also, and we'll talk about that in terms of the cost, the reality of this kind of litigation. But it is so essential because what Marcus is really talking about is what we do on our team is we help connect dots for judges by taking all that information and putting it into usable, manageable, charts, information, whatever, because a judge isn't going to, we don't have time in a trial to go through 1,000, travel records. But we had a beautiful chart. This chart that Marcus and Jared and Jordan helped put together was awesome. And it was able to be given to the GAL and the 604 and the judge at trial to say, here's a summary. Look at, if you look at a calendar and you see all of these shaded boxes representing days that the mother was traveling out of state, it was very impactful. And like Marcus said, was in a short order form that we could look at it quickly, had a tremendous impact. It took a lot of work and time for that short demonstration, but it was powerful and it was effective. And so that's an example of how we help connect some of the dots for the judge. That's our job. That helps persuade. And I'll say this too, in terms of the process. This kind of trial is not cheap. This is a tremendously expensive process. And part of why our client in this case went through this process was because after 2 or 3 years after the divorce, realized things aren't going to change. We challenge people and do the opportunity cost analysis and saying, yes, you're going to spend this amount of money. But the difference is a lot of times people settle and they say, let's just go 50-50. Let's just joint decision on everything and it'll be fine after the divorce. But it's not, because sometimes there's mental health issues. Sometimes there's other issues that things don't change. And year after year of dealing with this, and the kids get caught in the middle of this stuff. That was really what was at the core of this. The kids were suffering. And so it's a hard decision to make. Do I just settle to get out of my divorce, not spend the money, or do I tackle this now? And that's a tough decision. You have to talk with your lawyers, and assessing that decision as to whether or not you should spend that money. You want to have some good team around you saying, hey, do I have a chance at winning this? And we are a team that we will challenge people, and we'll say, do you want to do this? Do you want to spend the money? But we believe in our abilities, and we've had a lot of successes in cases where a lot of other lawyers simply would have just told the client, just settle, we can't win.
And I just have one other thing I wanted to add to something we were talking about in the prep on this, because so much is about getting the right information to the GAL or the custody evaluator when they're preparing the reports. And a lot of the times we see, if you're not properly prepared, and if you don't properly get ready when you sit down with the 604 or the GAL and they write their report or they reach their conclusions, they haven't considered everything, all the dots we'd like at trial. Another part of our job in putting on this trial is figuring out if you have not been prepared properly or you didn't do what was needed, how to correct that later. How to get the information that you wish the GAL saw, that you wish the 604 saw, and get them to understand that and not just defend the recommendation that they reached, but consider new material that they didn't have, and realizing that they might have reached a wrong recommendation, or the recommendation might have been off in different parts because you weren't properly prepared when you sat down the first time, or you didn't message yourself properly when you sat down. So while we'd love nothing more than to have a client who walks in perfectly prepared with everything they need, we know it's not necessarily always the case, whether it's we're representing you at that time or it's subsequent to that and the report's already come down. It's not all lost then. There are other ways as well to help connect the dots.
Let me, and Jordan, I'll have you chime in, but you mentioned preparation, Jared, and it comes to this, and our founding partner, Miles Beermann, loves to quote John Wooden when he talks, failure to prepare is preparing to fail, and it's such a truism pretty much in anything in life, but essential in this kind of stuff. If you haven't put the legwork in from a strategy standpoint, from a consolidating and organizing stuff before you even go into this evaluative process, the probability of success is very low on the back end. And then the only other comments I would dovetail off of Jared's comments are, when these evaluators do come up with their opinions and their recommendations and rulings, we don't just blindly accept them. Taking the deposition of these people, challenging them on their opinions. I think as a team, we did an awesome job at this trial of really, I think, diminishing the credibility of the GAL and the 604 by really highlighting that kind of what Jordan said, the 1 + 1 doesn't equal 5, guys. I know you said that in your final conclusion, but it doesn't. And when you challenge them and say, wait, you said this, you wrote this, right? You testified to this. Yes, yes, yes. You box them into a corner. And I think that was a big part of what we did is, we didn't just say, okay, well, the recommendations say this, we're fine with that, we can't win. We looked at that substance and said, there's a lot in there that they need to be challenged on. And when you challenge them on that and they can't really give a cogent response as to why 1 + 1 doesn't equal 5, they look really bad in front of the judge. And that gives you that opening.
Yeah. I mean, there's also so many components to this also. And I mean, even just, I think as lawyers and as a client who's going through this, I think you also have to understand and conceptualize what the issue is and what's at stake. Because I think that there are a lot of cases where the issue is not grand enough, so to speak. And again, it's all subjective, but it's not grand enough to actually take the deeper dive. And I think that at least us in giving our clients that option is tremendously valuable to people. Whereas I think a lot of people would just say, read the recommendation, done, goodbye, it's over. I mean, I think that to have that understanding to make the decision that, regardless of cost, would be in your children's best interest is something of tremendous value that I think we do a really good job of providing our clients.
Yeah, and it helps in these kind of things that for me as an individual and for us as a team, I think the more someone tells me or us we can't do something or the deck is stacked against us, that's just all the more motivation. And, you know, I mean, we will dive in on any issue. We work hard. You know, Marcus, you know, you talked about some of that legwork type stuff. You know, it really is a team effort, and it really does require a really a fundamental belief that this is something that is in the best interest of the children, and that we can deliver this message in a very simplistic way to the courts that they can look at that and really understand. So, Marcus, as the laboring oar in this endeavor, if you could, from your perspective, dealing with these thousands and thousands of pages of documents, if you had a message to deliver to a client early on in a process, what would you suggest to them in terms of how to approach just the preparation aspect of things?
Yeah, I think it's really important to be organized, to have all your ducks in a row. We talked a little bit about, you know, the cost of trial, having those real conversations. I think it's really important. And when we help clients every day find this, is what's your bottom line? For this case, it was a father who was really concerned about his children. He had a bottom line where if these demands weren't met, I'll settle, and it's a reasonable settlement. Those demands weren't met, so we had to go to trial. So, you know, so having your bottom line, being organized, you know, in association with knowing your settlement position, know what your priorities are. What are you trying to get out? Have you properly put that forth in front of the 60410B, in front of the GAL? Or is that properly being communicated to your attorneys, to the judge? You know, and get all that information in early, because the trial, as soon as we know that, you know, we're going to get hearing dates, we're going to get trial dates, the trial strategy is going to be set. There are discovery deadlines that we have to meet per the rules of Illinois. So you know, stay organized, have your priorities, and have your bottom line.
You know, I like one piece, you know, and you nailed it. And this is the thing, as a team, we always preach, we always really focus on this with any client that comes to us from day one, which is, where do you want to end up? What is your end goal? Because our entire strategy is built by reverse engineering from where we're trying to get to. So if you don't know what you're really trying to accomplish, and you don't know, if you say, this is what I want to accomplish along the way, are you willing to make any compromises, or is we have to achieve that result? Because Marcus, you pointed out in this case, our client was willing to make considerable concessions. And, you know, Jared, you spearheaded a lot of those settlement efforts. We tried every which way but Sunday to get this resolved. The GAL, you know, aided in trying to get this resolved. But, you know, in this particular case, mom wouldn't meet dad halfway or 3/4 of the way or 10% of the way. And it really necessitated our client either walking away, not achieving anything close to his goal for his children, or fighting the fight.
We all know there is a lot to the idea that if you end up going to trial on a custody case, you've already lost. There's a lot of risk involved. You put the raising of your children and the upbringing of your children into the hands of somebody wearing a black robe who's got a lot of discretion. So in every case, we do our level best to help find compromises, to help find middle ground. To Marcus's point, to explore and reality test, where can we make compromises to reach your end objective, your bottom line, right? And most of the time, honestly, most of the time, we're able to do it. It's not every case that goes to trial. It's the rare case that needs to go to trial. In this scenario, and in a couple of scenarios we've had, we're not able to reach that bottom line. And it's good to know that when you're not able to reach that bottom line, you've got the best team able to explain why what the experts were recommending or what the other side's proposing is not good for you, not good for your kids.
Yeah. And I think that is, it sort of kind of sums it all up together, that we on our team have trained mediators, collaborative lawyers, we practice cooperative law, you name it. We try every which way we can to settle, because oftentimes that's in the best interest of our clients and their children and their families. But to the point Marcus and Jordan were talking about organization, strategy, knowing what you want to accomplish. Again, the great quote, failing to prepare is preparing to fail. And that from day one, we always say, expect the worst and hope for the best, which means we need to be thinking in terms of whether or not if we go to trial, how do we need to be from the first step to the second step preparing for that inevitable? Because ultimately, what we all have found many times is when we actually prepare cases as though we are going to trial, that puts us in a better position. We have more leverage to actually then settle the case. And so, yeah, I wouldn't want anyone's takeaway from this to be, hey, let's just go and try every, what we used to call custody or child-related case for parenting time or decision-making. They're tough cases. They're very, very expensive, very expensive. And so, but at the same token, we've done a really good job, I think, of guiding those individuals who it's become abundantly clear they really don't have a choice than to try the case, to navigate them through that process and put on one hell of a trial. I mean, we did it in this case. This was maybe a 10-day case. It was a tough case and the deck was stacked against us. And so I congratulate all of you guys. I'm very, very fortunate to have, great attorneys on our team. Beermann as a firm, we have great resources. I'd like to think we have a very, very strong reputation with the judges and the legal community, and all that stuff matters. And so getting a win like this, I think enhances that reputation. It was hard earned. And so again, congratulations, guys.
Awesome.
So again, for the viewers and listeners out there, we say this many times, each case is individual to you. Your facts and circumstances are different than anybody else's. The needs of your children, your family, your individual needs. Our strategy, our approach is tailored to your needs, no matter what that may be, whether it's litigation or mediation or collaborative. But still having the underlying experience of knowing how to navigate you through any process, it's just invaluable. You can't go into something like this. And as Jared said, I think, talking about these are your kids. These are your families. These are your lives, entrusting that with a judge to make those decisions for you. You better know that you have people fighting for you that know what they're doing in that fight. And so if we can ever be of any assistance to you, you can always reach us. Our office line at Beermann is 312-621-9700. And you can check out our website, www.beermannlaw.com, and look at our profiles, look at our experience. If you just have a question and want to consult, if you have a case that's pending now and you're not certain what your strategy is and your lawyer isn't giving you that strategy, should you settle? Should you fight an evaluation? Feel free to consult with us anytime. So again, thanks to my partners, Jared Pinkus, because I don't know if the names pop up. So Jared, just make sure that wave your hand, Jared Pinkus, Jordan Rosenberg, and Marcus Dominguez. Gentlemen, thank you. And for all of you, have a good rest of the day if you're watching, or the evening or listening. And we're always here to help. Take care.
Thanks, James.